Hello and good afternoon, everyone. Welcome to Gagasan Mahasiswa Undang-Undang Sabah's very own webinar series introducing legal perspectives from Sabahan Advocates. Today, our third session is premised on criminal law practice and trial advocacy, where we will be discussing what it takes to be a criminal lawyer in this adventurous yet challenging field, and whether real-life criminal law practice is anything like the legal crime dramas or movies that we have watched. I am Nadia, your host for today, and together with me is my co-host Munira, who will also be moderating the Q&A session with the audience later. I invite Munira to list down some ground rules to keep in mind for this session.
Thank you, Nadia. Hello, everyone. My name is Munira Edward, your co-host for today. I'm going to lay down the ground rules for today's session. For your information, today's session comprises of two parts. The first session will last around 1 hour between the moderators and the speaker. The second session will be a Q&A session that will last around 30 to 35 minutes between the viewers and our speaker. Feel free to type in your questions in the chat box along the session. All questions from the audience will only be taken and answered by our speaker during the Q&A session later on. Also, please be mindful and respectful of the questions directed to the speaker or your comments regarding the session itself. In the meantime, sit back, relax, and enjoy the session. Over to you, Nadia.
Thank you, Munira. It is with great pleasure that I introduce our esteemed speaker of the day. We have none other than Mr. Ram Singh, a criminal litigation lawyer with extensive and renowned experience, as well as several prominent cases under his belt, as you would have seen from his speaker profile earlier. Without further ado, we will kickstart our session with some questions. Hello, Mr. Ram Singh.
Hi. Yes, I'm here.
Hi, all right. Okay. So we will kick off with the first question. So what made you decide to practice criminal law? Was it an area of interest that sparked since school days, or did it develop along the way in your career?
Okay, first of all, thank you, Nadia. Thank you, Munira. And then before I agree to your this live, in fact, we have written to CJSS, Chief Justice Sabah Sarawak, and he has given me the green light to give a talk. So we are free to talk, but with some conditions, otherwise you get arrested by police. And I don't want to defend you all. Okay, yeah. Your first question, okay, what makes you decide to practice criminal law? First questions, because there are few questions, inner questions. So
Yes.
why criminal law? Because I think I like the subject. You know, it has been since during my law school. Okay, that's where I pick up the interest. But before that, of course, when I was in my secondary school, I pick up that subject because of some incident that happened. You understand? So in the process of that, you know, I like the subject, but it didn't pick up until I started practice. Okay, until you start practice, you get on into the subjects, you try it, and then you like it, you try again, you fail, and then you try again, then you like it. So that's how I begin to do criminal cases from the beginning. Okay, that's answer your.
See. Definitely, yes, it does definitely. Okay, then with that in mind, then do you have tips then, like what field to dive in after we get called to the bar? Would you say that criminal law is a more interesting and exciting field than like a burdensome one?
Okay, well, if you like crime, if you like crime work, if you like to do into investigations, you like to use the word help others or defend others, why not? I mean, I'm sure you're doing criminal law now, isn't it? As a subject.
Yeah, for first year, yeah.
Yes, criminal law is a subject. Of course, in your subject, it is the basic. Okay, your law lecturers can teach you. Your criminal law lecturers, they are good criminal law lecturers who have written book. I've read it. But after your bar, why not? You can try it. Of course, when you first try criminal law, you don't do murder, isn't it? You do slowly
Yeah.
lah. You do mail
Yes.
applications. You understand? Your client get arrested. You go to the police station, and then you start reading the law. You ask around. So that is the start of your career into criminal law. And sometimes you ask your client to be on bail, and that is the subject that you initially start. Of course, step by step lah. And that's well, to begin with is, if you like criminal law as a subject, you like the some of the topics are quite interesting, and then you read in the
Yeah.
paper, that will be your supplementary, that kind of overview of it. So if you like it, why not? To me, of course, I do litigations. I do civil, I do criminal litigations. Of course, in the process, if somebody asks me, what's the percentage of criminal cases, I will say 70. What's the percentage of others? You'll be 30. So more criminal.
I see.
Of course, litigations in a sense. Understand? Of course, litigations, criminal and civil litigations. They are both. So long as you go to court, it's good enough. You don't have to be an expert. Okay.
Okay. But I have an extra question. You say that if you like criminal subject, right, and then when you do the exam, would you say that the questions in the criminal exam, like the scenario that they give, would you say it's pretty similar to real life as well?
I think so, because okay, when I look back now, when you do criminal work, especially the police will investigate on many issues. The police will investigate, like say murder, the police will investigate actus reus. You understand? Just because the guy is in the room with a woman, it doesn't mean he kills her. True or not? You understand? So actus reus.
Yeah.
If you find a knife, it could be the knife. So that will be the initial part of it. You have learned actus reus, isn't it? The fact that whether that is a weapon to use. Okay, then the difficult part will be in your subjects, including like ours is intention, right? It's a mens rea.
Yes.
Okay, intention. So you have to look at intention. I think in your subject there are recklessness, carelessness. Those days when I learned in UK lah. Okay, but here you have all the other tests of intention, right? So that is actually what you learn the basic in your subjects, and you apply it in the practice. But of course, practice, I can tell you one thing, mostly in criminal work, you are governed by the Evidence Act. You understand? So just like our celebrated case of Anwar Ibrahim, this is what the court says lah. Illegally obtained evidence are still admissible, isn't it? Understand? So you all don't go into that in your exam, but whatever it is, exam or whatever we do submissions is, whatever you do is the structure is there. You don't run too far out from what you learn in law school and what you learn in your initial cases of criminal cases. Of course, initially there are sentencing factors, there are mitigations, So not much difference, except for if a case comes to you, every criminal case are different. Every facts are different. Okay, so you learn from one to another, and it goes on. So to me, whether exam or in practice, it's the same. You pass, I succeed in my case, so same lah. So is that answer you? So initially, it doesn't matter. You have to go through this.
Definitely.
Okay. I hope it answers you lah. And I'm not
okay.
too
All right.
fast.
Thank you so much for that. Yes, it does. No, definitely not. Thank you. Okay, then I guess Munira, you can continue with the questions.
Yes, Thanks, Nadia. So I think just now it is a very insightful, even though it's just the beginning of the session itself. But my next question would be something sound like this. As someone who has yet to venture towards criminal law practice, our imagination is usually limited to the cases that we read, the students' criminal series, documentaries, and etc. And it often affects one's emotions, trying to fathom why this and that happened. So, in your opinion, does engaging with emotions in handling criminal law cases bring more harm than good?
Okay, I didn't get the questions, sorry, the mic is not, isn't it?
Okay, it's okay. Let me repeat. Okay. My question is,
You don't
as
have to
someone who
repeat.
has
You
yet
don't have to
to,
repeat the whole thing, okay?
okay, in your opinion, does engaging with emotions in handling criminal law cases bring more harm than good?
Okay. Okay. If you say similar cases, I can tell you, murder cases. I give you one example. Murder cases, murder cases. Basically, murder cases are all the same. Okay, they have the prosecution duties to prove motive, right? So of course there must be a death of somebody, lah. Understand? You can't do a murder cases like once I did years ago. My client was arrested for killing an orang hutan, lah. Of course, obviously, the scientific name for human is Homo sapien, isn't it? So orang hutan is not as Homo sapien, lah. They can be orang, but they are not hutan, lah. You understand? So of course, murder cases are like that. So basically, one case and another case, the prosecution will prove motive, lah. I don't know whether you have read in letters in the newspaper, the Cradle murder. Understand? It is in the paper, lah. The Cradle murder, the prosecution did not prove motive. That's what the High Court judge says, lah. Of course, they will appeal. So basically, murder cases is the same principle. Okay, they have to prove murder within Section 300. Okay, so for the defense, even though murder is always the same, we have it in mind, but we have to prove. There are a lot of evidence that we need to prove. Forensic evidence is one of them. Okay, motive is another one. So if you say similar cases, murder cases, yes. And then if you look at drugs cases, also capital punishment, okay? There's only one punishment for capital punishment. Do you know what is it? Death only. You'll be hanged to death by the rope. So in drug cases, they'll be different because the law is different. Whether you are trafficking, okay? Whether you knew what you're carrying is the drug, okay? Knowledge and conduct and whatever. So when you look at it, similar cases, yes. Not all similar cases have the same principles, have the same modus operandi. You understand? But once you do one murder case, you will remember what you have to do the next one. Of course, you have to look at the latest case. Our federal court, they are quite active now. And then they are active in the federal court, especially our chief judge. They take into account of what you call it, constitutional issues, even in the criminal case. You understand? So the courts, anything on constitutional, they do decide. So if you look at federal courts, as I always teach my lawyers and friends and even my daughter, is to read one case a day. It's so easy. You all have the website and all those things. So of course, it can be similar, but not all the criminal case, the tests are the same. Okay, so of course we look at previous cases of precedent. There are a few good precedent cases way back in the 50s or so. I can't remember offhand, unless you ask me to submit. That's why, like I told you just now, sometimes it's better to, to argue in the federal court where specific cases are on. Okay, so did that answer your question?
Yeah, but with regards to what you just, yes, Mr. Ram Singh?
yeah. You did ask about emotions in cases, isn't it? Just now, is that?
Correct. Yes. Mm.
Okay. Okay. I see your question. Does engaging with emotions in handling criminal cases bring more harm than good? Practical. If you win a case, a
Yes.
murder case, you think the victim family will like you? Okay, they will haunt you like hell. You understand? So of course,
Mm.
winning a murder case, of course, they are good and bad lah. Understand? For you as a lawyer, you win one case, okay lah, fair enough lah. It's an achievement or something that the judge believes the client's stories lah. But on the other hand, of course, the victim family will not like you lah. Understand? So, but if you want to handle a case, like I saw one of your question is, of course, he's innocent until proven guilty, right? So when you want to fight a case, forget about emotion. You have to have a strong heart, lah. If you are emotional, I don't think you can do it. Okay, whether you think your client is right or wrong, forget it. You just have to fight the case. To help him. If the court believes you, then you may succeed. Otherwise, there's some extent where the cases, which way you're going, then you can write and do a representation. Representation to the federal AG. You state your case and you say, hey, look, can I have the case reduced instead of my client being hung to death? Maybe lower the case or what. But emotions, yes, we do feel. We do see that some cases, the way the murder happens is quite brutal. I've gone through that, but put a strong heart, fight to the best that your client, for your client. Once you get emotional, some lawyers I've gone through, halfway they decided they can't handle it, they discharge themselves. Fair enough. The court cannot say, look, you are incompetent in that sense. Okay, but but I will say that be brave and argue your case, lah. Of course, lah. Some people ask me, hey, he did it. I said, yeah, lah. How do we know that he did it? There are so many things happening. You understand? Everybody will say he did it, he did that. But well, if you take up the job, stick to it and go through with it. And then if he's sentenced to death, you don't go and tell him, hey, look, maybe that's how you did it. Don't. They're already affected. They will be sentenced. They're already sentenced to death. So use a bit of psychology, use a bit of comforting words. So emotion, definitely other emotions. But not that kind of boyfriend-girlfriend emotions. Lay the thing off. Listen?
Noted.
Okay, criminal emotions are different. Okay, next.
That was a very refreshing view in the context of emotion and dealing with criminal law cases. My next question will be something more light, relatable to its law students or students in general. We all know that anxiety or nervousness is a very prevalent issue for law students when it comes to advocacy practice in court. So have you ever had to deal with this in university or ever even in your career, and what are some of your solutions in overcoming or coping with this problem that you can share with the audience today?
Okay, as a student, I was once a student also, okay. To pass criminal law is already, you're nervous, you understand? Understand? Whether you can pass the criminal subject or any exams is already nervous, isn't it? Okay. And then when your first few cases in practice where the judge will be looking at you, understand? The judge will be like a hawk, with the eyes, glaring at you, and looking at you. And I'm sure, anyway, this is my experience 30 over years ago. The judge must be thinking, hey, this guy knows or not. Understand? Of course, they will put one or two questions to you. And then when you get nervous, obviously you can lose your ideas, lah. Understand? Stay calm. Always stay calm. You know, if you have to answer your questions, you think, you know, you count in your heart and say 1, 2, 3. Close your eyes, and then when the judge or the lecturer asks you, you have that. You pause for a moment. Okay, 1, 2, 3. Use your finger, use your mind, having to pause your mind for a while may helps you to recollect certain things, lah. Of course, nervous is there, lah. You know, 30 years ago, who said I'd be lying to you if I wasn't nervous, lah. You understand, lah? Nervous is there. As a student, as a lawyer, you know, and then some judges. Imagine if 30 years ago, when I started practice, the judge sitting up there was already what, maybe 30 years in practice. Okay, of course I'm 60 now. The judge is already resting in peace, lah. You understand, lah? Okay, so of course I was nervous, lah. When we went to England, we were told to even though I was educated in English, we were asked to do some English tests and all those things. Sometimes they look at us, and say maybe we don't know how to speak English. Same thing. So nervousness, yes, 100%. But don't take this nervous thing that stops you from getting on your career, lah. You understand, lah? Why? Of course, lah. People say to me, I'm a criminal lawyer for 30 years. I will set criminal law, lah. You understand? Obviously, lah. You know, you don't be embarrassed to say yes. But I do a lot of civil litigation. You understand? So if you say that, what are some of your solutions in overcoming and coping with this problem? Share with the audience. Stay calm, lah. Just like your dad will tell you, your father also must have studied something and will tell you, the same thing. Stay calm, be nervous. Yes. Who are without problems? True or not? You see? So what you do is, exam and careers, it can be taxing, lah. I'm not saying difficult, you understand? But it can be taxing, because if you study exam, sometimes you burn midnight oil, isn't it? Right? You think you prepare the case, you don't do, you prepare also, lah. But sometimes my lawyers will say, I don't prepare, lah. But but we run it back and back in our mind, understand? So like every time, after your lecture, you go through your notes, right? So you refresh your memory. So if you prepare well, why should you be nervous, right? If you don't prepare, God help you, lah. You understand, lah. So nervousness, mesti ada lah, takkan lah tak ada, betul ke tidak? Cope with it. One of the senior judge told me once, that was, many years ago when I started practicing, even my seniors, they said, if you say that you have butterflies in your stomach, right? You train the butterfly to fly in a formation. You don't let the butterfly fly here and there. Okay? You try to fly it in one line, lah. Of course, you don't beat your stomach during the trial, lah. You understand? But you tell, hey, damn, you better behave yourself, Okay? So that is my answer to you. Sorry.
All right. Thank you, Mr. Ram Singh. No, I really appreciate the answers just now. I think it's really, really applicable and so relatable to us law students, especially.
Yeah. Sometimes if the judge scold you, be humble, lah. Like what
yes, nervousness is always going to be there, but what we can do is
okay.
Noted. Be humble, stay calm, and just take a pause, take a deep breath, and then handle the issue. Yes, Mr. Ram Singh?
Yeah, if the judge or lecturer scold you or your parents scold you, go and watch Cinderella, lah. I keep telling you, Cinderella movie? Cinderella, the most beautiful lady in the whole world, was tortured by all the other sisters and stepmothers. Watch Cinderella, and that will give the answer to you, which is question number 8. Think so. Never mind, go back and watch Cinderella.
We'll go back to the questions number 8 later. So I think for
Yeah.
now, I'm going to pass the floor back to Nadia.
Okay.
Okay, all right. I really like the putting the butterfly in a formation advice. That's very refreshing. I've never heard that before. So thank you, and I will keep that in mind. Okay, so moving on. If you don't mind sharing, can you please give us a brief layout of the criminal trial process from the preliminary preparation up to trial in court, to walk through our audience today?
Okay. 30 years ago, we were not lucky as you all. Understand? Today, you all can Google, ma. If you don't believe me, you can Google and say how to argue a case, right? So Mr. Google will help you.
Yeah,
But
most
30
definitely.
years ago, is what we do is trial and error. Understand? There were no computers. There were, whatever he said, we have to do all handwritten. We write it down and all those things, right? But make it simple, okay? Trial work, normally like criminal. I give you a criminal case, criminal case. The prosecution will start, okay? Okay, okay, this guy, he found he has committed murder. Understand? He was, of course, when he is detained, he is called a suspect, right?
Yeah.
And then after that, after the police investigate, call all the witnesses, and of course he's remanded for 14 days. Then if there's a case to charge, then the prosecution, the DPP will charge, right? So he's called accused lah. Don't get it wrong, suspect dulu, baru pergi dia jadi accused lah. Okay, in the process of remand, and then they will investigate all the documents, the phone. Make sure no funny video on your phone lah. You understand? So everything will be scooped out. Even though the prosecution will get from your video, from the phone. We have one case a couple of months ago. There were 30,000 pictures from the phone lah, kena extract lah. Okay, but 30,000 pictures. Don't worry. You think the prosecution will go through one by one lah? Okay, so don't worry lah. They don't have time lah. Rest assured about that lah.
Yeah.
Okay, then all the documents will be served on you before trial. The serve on you. Of course, your client will be read the charge lah. The first thing is charge. You know the charge. What is a charge? Charge is pertuduhan lah. The charge is the first page of your Bible. I always tell my student lah. The charge is what it says. On this day, you blah 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 in this place have killed somebody lah. Understand? Kill somebody and you have committed murder lah. Take it that way lah. Okay. So the charge. Then all the documents. Okay. The documents starting from police report. Somebody, your neighbor screaming and say, "Hey, I heard at 5 o'clock in the morning somebody going. I heard this name. Ow, ow, ow. Satu report. Ow, ow, ow." Okay. So you as a defense lawyer, the ow, ow, ow could be a dog barking lah. Okay. Sorry lah. So they will compile all the documents. Okay, all the documents. Then, for the case of murder, your client will be brought to the magistrate court. Magistrate court is where the first court of cognition. Dia kena charge the magistrate. Okay, whatever charge lah, whatever in this world lah, you get charged. I mean, in Malaysia, you go to the magistrate. Okay, I don't know whether your lecturer have said that lah. So you'll be before the magistrate. Then after that, the DPP will look at the document. You look into the forensic evidence. You look to the post-mortem. You look at all the other evidence. Then chemist report. All these are called forensic evidence. Then there will be a charge, murder charge to the High Court, right? For murder cases, capital punishment High Court. All right. So pergi High Court. So High Court they will charge, and then they will take a process of, well, the law says within 5 months from the date of arrest, he will be brought to the High Court. They will give you a bundle of documents lah. Okay, I don't know whether I have it here. So the bundle of documents will be thick bundle under section 51A. Okay, so you cannot go through lah. Okay, go through. And then lately criminal cases has is more like a civil case now. They have the document. You agree whether these are admitted documents and disputed documents and all those things, right? Okay, they will prepare the fact of the case lah. Okay, they'll prepare like murder. I can tell you the first thing is that they will say there's a death of somebody lah. Understand? Memang ada satu orang kena bunuh, satu orang mati lah. Takkan dia kena bunuh dan tak mati, betul ke tidak? Okay, so of course you agree lah. You don't dispute the guy is dead or not dead lah. Okay, and the rest, my experience is whether you agree or disagree or disputed, no effect at all. So it's better for you to dispute everything, because at the end of the day, the prosecution is going to present the case from the beginning until the end, beyond reasonable doubt. I don't know what's in Malay, but beyond reasonable doubt. You learn that. Okay, so that is the preparation of document. Then you will appear in court. Of course, you tell I don't know, maybe you all want to be prosecution ke defense. Criminal law ada dua. You all may be a magistrate ka, registrar ka, DPP ka, or defense lah. Understand? So, so from there, you will see the documents, and then you will go through. Then there will be a process of pre-trial case management. They call it PTCM. Okay, pre-trial case management. Okay. There, where you will be looking at it and see whether the documents are sufficient or not. Okay. So if you are familiar with your case like murder and all those things, you have to set your defense. Betul ke tidak? You also will set up your defense. So during the PTCM, the prosecution will present the case, list of all the cases, right? Okay, I mean the documents lah. Okay. Then if you think that you have your own document that to support your defense, remember you have to support your defense, right? Okay.
Yeah.
So maybe you need a second opinion on the pathologist. You know, people who does post-mortem, you call it forensic pathologist lah.
Yeah.
We have
so like calling an expertise, right?
Correct, correct. So we have always call a pathologist. Of course, in our practice, we call Dr. Bupinder a lot lah. Datu Dr. Bupinder. So he has helped us a lot, and then we will present the case, right? Okay. So whatever documents you have lah. If you think that your client's phone has been detained and there are some important evidence there, you can always write in for that document, or you make an application to court. You want further evidence. Understand? Don't go and straightaway say, I want a trial that fast. Okay. Once the trial started, you cannot say, hey, look, I forgot some documents. Okay. That is actually wrong. That you, at the end of the day, another person may take over the case and say you are incompetent. Okay. So prepare your case. Your client will say, in that phone, I have all the things. So minta balik the phone through an application in court. You can't say, hey, look, you knock on the door of the court and say, I want my phone back. Okay, they laugh at you lah. Okay, make applications in court, and then you look at the police report. And then in the section 51, they will give your client statement, the accused man statement lah. Okay. The beautiful part for the prosecution is the prosecution will interview everybody, okay, including the accused, which is your client. Okay, even your client will admit everything, they will use it, but they will give it to you. Okay, so what you do is you have to interview these accused, they punya kawan-kawan. You understand? So you have to prepare your case in that sense.
Or you also interview them.
Of course, of course. Okay, of course. So, but your accused clients or your witnesses may not be in the list by the prosecution. Okay, so one of the lists given by the prosecution is the list of witnesses. They can have 30 witnesses. You understand? Okay, so you have to go through it. If you think that partly, you see, lately there are a lot of cases where they say they arrest you in one place and then they brought you to another place. They say leading to discovery. Now, have you read evidence leading to discovery? Okay, leading to discovery is like this. Okay lah, you arrested me. I murdered somebody, but I threw the knife in the river. Understand? So they brought you to the place. So some cases, okay, don't want to confuse you. Some cases may amount to admission because they cakap confession mah. So things like that you have to challenge. So during the pre-trial case management, don't be embarrassed. Tell the judge, I do have some documents. I'm waiting for some documents. Understand? So this is the case management thing lah, with all the documents. Okay, once everything is ready before the trial, they will give you another PTCM, right? Okay, then you will say that, look, you will ask the judge normally will guide everybody and say, have a witness statement. Okay, so witness statements from, if the DPP is very rajin lah, sorry, DPP is here, if they are very rajin, they can even have 14 witness statements. So be careful, read the witness statement. Sometimes the witness statement, if tendered into court by this witness, because there's a federal court case to say, hey, he's taken as read, you know. So the judge will say, taken as read, is this your statement? Mark it. Then they will ask you, Mr. Singh, can you cross now? You don't go and say, because he says setengah jam lah. Understand? So you have to prepare yourself. That is why we have the PTCM. Okay, so now judges are hardworking lah. Okay, so what they do is at the end of the defense, at the end of the case, prosecution, they will close the case. They will close the case. The judge will ask you to submit the next day lah. Understand? So the next day, next day submit lah. Okay, then the defense stage will be your client plus their witnesses, right? So preparation is very important. Okay, preparation is very important. And what happened there is, okay, if you think that you have some issues in between, okay, like lately a lot of people murder cases, they want to apply for bail applications. You understand? To get released from court lah. There are a couple of cases lah. Kimberly will show you some cases later on lah. Okay, so you can make those applications in between that lah. Okay, doesn't mean you apply everything is granted to you, right? So preparing of documents is very important. You know, go through them. Sometimes some hidden words and say, you know, they say look, very important lately that the police will say after soal siasat dibuat, he told me that he actually killed the person. Okay, you don't sit down there and sleep lah and say that is very damaging for your client. You understand? Okay, itu inadmissible. So be careful. So you have to read every part of it lah. You understand? But some will give a witness statement, very short witness statement, and then in the court they will give you a lengthy further question. So that is also another trick by them lah. Understand? So my question is this: prepare your case. Prepare your case, and you know, it's just like preparing for exam. Okay, and not sure, ask. You always write. The best is to email to the DPP and say you need all these things. Okay, and then anything that you need, we have in the system now to say that we can upload those letters lah. It's quite easy nowadays. Okay, so preparing of cases is very important. Understand? So basically, in short, prepare your case. That's what I'm trying to say. So does that answer you?
Thank you so much. Yes, definitely. I mean, I'm very grateful. I'm sure the audience is also very grateful for that precise and detailed explanation. You did mention earlier that it's pretty similar to an exam question, and the way that you explained it, I did learn this in school too. So it's really interesting to see it come to life.
But for exam,
my next question ties into the personal strategy.
Okay, but in exam you trust your lecturer, but in the criminal case trial, don't trust too much. The prosecution.
Yeah. I mean, it sounds definitely harder. So actually,
you remember,
my next
you don't want your client to be hanged to
well,
death, lah. You understand?
Yeah,
You know,
yeah.
when your client gets
Mm-hmm.
sentenced to death, the judge will look at. Do you know
Mm-hmm.
what they read? They will look at the penal code. I tell you what they will
Yeah.
read, lah. I hope no judges are listening, lah. Okay, you know they will read. Very sad, lah. But what to do? The law is like that, lah. Understand, lah?
Mm-hmm.
They will say,
Yeah, yeah.
hold on, they will say that after hearing everything, after hearing all evidence, this and that, I hereby sentence you to death, by hanging you by the rope and hanging you to death, how sad it is. So never mind, but that's the law, lah. We only have one punishment for capital punishment, which is death, hanging by death,
Mm-hmm.
Hmm. So fight your case, fight it properly, lah. Jangan setengah-setengah, lah. Okay.
Yes,
Otherwise,
definitely.
okay. I hope that settles it. Next, apa?
Actually, it was about personal strategies, but I feel like you have touched on that when you say about the case management on when you take criminal cases, right?
Yeah,
Like
but
how that's like the most important part.
I saw your
Mm-hmm.
question. Investigative strategies. Of course, when you want to fight for your
Mm-hmm.
defense case, you don't go
Yeah.
and tell the prosecution, lah. You understand? You keep it. They say keep it. The best is the last act, lah. You understand? The last is the best act, lah. Something like that. Don't tell them everything, lah. You understand? Don't be too nice to
Definitely.
tell
Yes,
them.
yes.
But I have not gone through
Mm-hmm.
that is the document in the process of trial. Okay, in the process
Mm-hmm.
of trial, if you want to set your question, I can tell you, like, take for example drugs, drugs cases,
Mm-hmm.
trafficking. The important witnesses
Okay.
are the raiding team. Okay, the raiding team, the person who arrested your client. Okay,
Mm-hmm.
so you have to, during the trial, when the moment the light turns green, okay, you have to ask relevant questions to help your client. You understand? Hmm? You
Yep.
have to say, like, hey, look, he did not say that he sold the drugs. Like, you have to put questions. You understand? You have to ask relevant
Mm-hmm.
questions to support your client. Okay, during the prosecution case. You understand? Because during the trial, your accused will just listen to you, listen to you, looking at your face, like, hey, my lawyer, betul ke tidak ini, You see, so you have to ask relevant questions from the first witness until the last witness. You understand? You don't keep it to the last minute.
Yeah.
Otherwise, the judge will say afterthought. They love this word afterthought. Afterthought is, what is that? Pemikiran selepas. So you have to
Mm-hmm. Mm-hmm. Yeah, I
remember,
understand what you mean.
during the trial, you have to set your questions to during the prosecution case. Understand? There are a lot of good
Mm-hmm.
cases on this, Eichming and all those things. You understand? A lot of cases. Later on, maybe we will email to you some of the cases that I have said, then you can share it,
Oh,
okay?
all right. Thank you so much.
Okay. So prepare your case. Jangan buat setengah-setengah, lah. You understand?
Yes.
And then we get some senior lawyers like me and say you did the trial, and sad to say, when we say the lawyer incompetent, yeah, sad lah, boss. But what to do?
Mm-hmm.
And then they say, there are cases. If you look at it, a Tawau case, PT also, don't mention the lawyer. I think the lawyer did his best, lah, but he wasn't well. Okay, and then the client was convicted, sentenced to death. Okay, so another lawyer took over and used the excuse to say that he is incompetent, lah. Okay, I don't think that lawyer was incompetent. He could have not been well, lah. And those days, once you take up a case, you cannot postpone. You understand? But if you are not well and you don't feel good, use a medical cert, discharge yourself. You understand? So the case was taken up on the issue of incompetent counsel. Said like it started
Oh,
off with
wow.
Understand? So, but
Yeah.
in the end, the accused was from capital punishment, from death penalty to what do you call this, reduced charge lah, from 39B to 39A2. Okay, so whether it is good for the lawyer or bad for the client, at the end of the day, we take it that, you know, we shouldn't use incompetency as an issue lah. But if terpaksa lah, understand? So prepare your case. Just like prepare your exam lah. Okay, that's okay.
Okay, thank you so much. Okay, and then Munira, you want to continue?
Yeah. All right. Thanks, Nadia. So I think we just can move on to the next question from Mr. Ram Singh here. Do you think that a lot of crimes are actually down to serious social issues within the more marginalized or disadvantaged communities? And is it more favorable for this issue to be dealt with in a social sense, such as having community rehabilitation programs rather than dealing with them through a legal manner? So how do you think this issue should be balanced?
Okay. Of course, crime are related to social issues lah, right? That's obvious lah. Crime, social issues lah. But again, not all crime are social issues lah. You know. Sometimes I can tell you, murder. Okay, put it this way: whatever murder cases is a one-to-one effect, right? One-to-one effect. There must be a provocation. There must be some other issue, some other defense lah. You understand? Okay, that's murder, right? Okay, that's murder means one person there's a fight and die lah. Okay. Okay. If you look at rape cases is because sometimes most rape cases, the way I look at it is the victim and the accused, they somehow know each other lah. Understand? Okay. So that is a one-to-one matter. But at the end of the day, I give you one example about rape cases. Rape cases, if they know each other and then certain age element, of course, underage, don't do it lah. You know, sometimes parents and you know, where they have relationship, that's bad lah. You know, incest and all those things lah. Understand? Then we have another case. I give you another scenario where the drug cases. Okay. Drug cases is, you know, imagine if the guy is trafficking for 30 kilo. Okay, they will say, look, 30 kilo maybe they will affect a large number of the community lah. Understand? Okay, but then again, all these serious cases are different in nature. Understand? The drug cases, you don't get the, you don't get the real culprit lah. You know, you get all these pushers lah. You understand? These are the fellows that normally get arrested lah. The person who transport this and that lah. Okay. Sometimes when you look at rape cases, they know each other and all those things, right? So most cases in rape, unless there are some cases I've gone through, I'm talking about my experience. Some of them are consensual. You understand? Murder cases sometimes can be provocative, also like provocations and all those things. Okay, if you look at the serious cases, like we did one case, murder cases, rape cases, you know, the guy, 4 charges, sentenced 18 years. So imagine 18 times 4 consecutive means 72 years, you know. And then if the guy is 58 years old, do you think it's worth it to stay in prison 72 years? You understand? So we do have this. Now some judges are working on it, on what you call this rehabilitations, like, you understand? And then not only that, the law have also stated, the Court of Appeal or Federal Court judges are in mind of, comes to rape cases, they call it the crushing effect, you know. They don't send the guy there knowing the guy is 60 years old and then serve 48 years. Come on, he will die there, you understand? So they will reduce it, taking account of the age, the family, you know, if he can survive. Lately, we have one case up to 30 years, still still a long way, lah. You understand? So reduce 1/3 becomes 20. So the court looks into that now. Okay, so comes to drugs cases, of course, capital punishment is only one punishment, like what I said, death by hanging, lah. Understand? So they have also changed the law under they have amended the law from death penalty to 39B 2A. 2A is where the courts look into the role played by the accused, lah, whether he can reveal all the information. There is an ongoing case in the federal court now with the three options. I think the case is Taza's case. We'll give it to you, lah. We email to you. Taza's case is at the federal court. Whether the role played by the accused, whether the court can look into it, and instead of death penalty, it's reduced to life imprisonment and 15 strokes. But still, to me, life imprisonment is for life, for life, maybe 35 years. Understand? Whereas natural life and life imprisonment, okay? If I'm not mistaken, on the practical side, to get into what you call this pardon or look into yours, you have to serve like 20 years first, something like that. So that also is a long time. Okay. There are cases where murder cases has been reduced to manslaughter, but then again, you can't blame judges, like if the killing is so brutal. You understand? Some of them are mentally, and some judges say that, look, I cannot, even though mental illness is an issue, if you sentence the person to 25 years, he may go on the streets and start. You understand? So judges have taken into account of all this, so as lawyers represent our case, you understand? We present our case, and of course, whipping, the maximum number of whipping is 24, you understand? 24 times, You don't ask me after 3-4 times how painful it is, unless the accused comes and tell me. But sometimes they say it is really painful, understand? So retribution and rehabilitation, the court has taken that into account through amendment of law, and hopefully one day we abolish capital punishment, understand? This death by hanging. You don't hang a person, that's all. I'm against it, honestly. You understand? But what to do? The law is there, unless they change it. But we are moving towards no more death penalty. And then some cases where the magistrate level have also looked into community service. You understand? Community service of 240 hours for some, not to say serious offences, understand? So the court is looking more positive towards this. Community services, I don't know what it means, but cleaning toilet, I don't know. I hope some judges are listening, they can tell me, they can correct me. But community service, maybe, I don't know, but it's a wide definition, understand? Yes, so they're looking more into that now. And then, of course, don't be embarrassed to tell the judge, look, you have done so much of research, and you say that maybe the best for my client is, not to sentence them for long imprisonment. I think you tell them, even you get quarantined for 14 days also, you feel like going crazy. Understand? 14 days quarantine for COVID. What about them? So present your case, Some of them are good listeners. So far, judges have been very nice to me also. Okay, so I hope it answers you,
Yeah, I think that was it was very insightful for me. I think not just me, but even the viewers. So I would say that in terms of whether we should have rehabilitation programs, it depends on the type of crimes itself. And I believe your personal view is you are against capital punishment, which you think that it should be. Can I say you think it should be abolished?
yeah, capital punishment, I say should be lah, but it takes time lah, you know. But that I think you're a law student. I'm a I'm a lawyer. Let the parliamentarians argue in parliament lah. We stick to, unless I be a politician, then I can answer for you lah. But bear in mind, no matter how much we want the sentence to be reduced, sometimes if my clients get off, and acquitted, they will be this social media always harassing them lah. You understand lah? So, well, what to do? Okay, so that is there are good and bad side of it lah. Understand? Okay.
Alright. Thank you, Ms. Ram Singh. I think with regards to my question just now, I always remember what my lecturers told me, that you can read the social media, but as a law student, you know that social media should not be your main reading materials when it comes to cases like this. So I think now that whatever that you said just now, I should put that in mind, and I just remember what my lecturer told me the other day. So I think, Nadia, you have the next question. Thank you, Mr. Ram Singh.
Welcome.
All right. I think because we are running out of time, is it okay if I ask 2 more questions? Is that fine?
Can. As many as you can.
All right. Okay. The first question of that is, what are some of the vital skill sets that one?
Okay. This question. What are some of the vital skill sets that one must possess in order to be credible criminal lawyer? Vital skill. There's a difference between a lawyer having a gray hair and a black hair, you know. Understand?
Would you like to further explain that?
Gray hair got wisdom lah, right? So with the, you must have full of wisdom lah. You understand lah? And then the other thing is practice the law. Remember, I was once told by my senior lah, you know, very very senior, even the late Karpal lah. He always said, you know, YB Karpal. He always said this, you know your law lah. Understand? You know the law. You know your law, and you read something. He always says, read a case a day. You understand? So of course, vital skills one possess in order to be a credible criminal lawyer is trial and error lah. You know, trial and error. So it's through practice. You know, of course you can't be losing cases all the time lah. You understand lah? You must win cases lah. You understand? Yeah. Sometimes as a defense lawyer, we call ourselves defense lawyer lah. Okay, defense lawyer is quite important. You see what happened? Even the accused statement is kept by the prosecution. You understand? The prosecution knows his stories. Okay, so we as a defense lawyer, we must be better than David Copperfield. You know who is David Copperfield? The magicians lah. So we must have some magic also lah. Must have some magic, but don't go to the extent of arguing and fighting in court lah. You know, exchange of words and all those things. If you can avoid lah. If you cannot, apa boleh buat lah kan. But the skills that I can tell you lah. The skills I can tell you is make sure you know the law. Okay, you know your stuff lah. You understand? Number one. Number two is, because as a criminal lawyer, your cross-examination is very important. Okay, you know, no cross-examination.
Yeah.
You cross appropriately. You cross the witness if you think you know what the witness is going to answer. You don't go and cross. You know. I give you one example. This is real life experience, not by me lah. You know. You don't go and cross the witness and say, hey, I put it to you, you do not see the crime. You understand? I put it to you that you did not see the crime. You know, you did not see that killing. The guy says, I disagree lah. You don't go and add on another question and says, like this is real life, you know. I'm sorry lah. You know, he says, how do you know? How could you see? Okay, the winner says, itu bab atas kepala saya tau. Saya nampak tau. Understand? You know? So the client actually went down his chair and went underneath the witness box. So don't do that. If you think you know the answer the witness is going to say, cross. If not, do not cross. You know, some judges may disagree with me lah. I'm sorry lah, but when it comes to legal points, strictly legal point, no need to cross. You just submit it. Understand? You don't go and say, hey, he did not kill you lah. You know, I mean, don't say that lah. So your cross questions are very important. You understand? So that is the skill that you acquire after a while. Okay, so you write it down lah. We also have notebook lah. You know, we write down all the things. You know, mistake in one case, we remember in another case. Understand? You don't have to be the brilliant lawyer in the whole world lah. You know, I don't think they are or there is a brilliant lawyer in the world lah. Understand? Okay. Just because I win so many cases, I'm not the best lah. You know, there's some others. Okay, there's some others, but we learn from them. And then the other thing also, have your own group of contemporaries. Understand? Contemporaries means talk to the other fellow. We have friends in Semenanjung. We have other. You know, I keep in touch with some senior lawyers there. Sometimes we talk. You know, so we exchange. You know, that kind of thing. So if no lawyer is going to talk to you, you make friends yourself with Mr. Google lah. Google everything.
Okay.
That's my answer. Okay.
All right.
So next.
And then, yeah, okay. So my final question of the day, which I think you are very interested to answer. So what was the most challenging yet humbling case you've ever experienced?
Most challenging. Most challenging. Of course, if I talk at length, I think the special branch is going to question me lah. Understand? Okay, but they were nice. They were nice when we were fighting the case. The intrusion case, Tandua's case, where the certain groups waging war against Awagung. That was good. That was the first case where you know the Act SOSMA, okay, the Social Special Preventive Act SOSMA, where SOSMA was released, you know, and then after that, after our case, they amended Section 18A to say that anything they say is admissible and confession, you know, and then we have all the other IC's case. You understand? So these are the cases where we get one bombing of here and there in you know. So these are challenging parts where in the process of lengthy trials we learn quite a lot. We got the best DPP, the prosecutions from from Putrajaya, and we learn a lot from there. Of course, the other case, of course, involving when we do a lot of pro bono. We help a lot. We help a lot with all these pro bonos, and then we help a lot with the kampung people on native rights. Okay, native rights. A lot of landmark cases where we have we have actually helped the kampung people also. I mean, sometimes at the end of the day, share your thoughts, share your thoughts and share your loots also lah. I mean, we can't be thinking of money all the time, isn't it? So of course the earlier part of my case where it is very challenging is I defended my own brother who was charged for reckless driving. That one I just graduated from school. That was a nerve-wracking thing.
Oh,
So
I see.
we take it as a challenge, step by step. Of course, if you have to defend your own childhood friend, you understand. So that is a challenge,
Yeah.
you know. Of course, lah, you don't simply reject it. But again, like what you said, we learn through trial and error, lah. You know. Only thing is that we cannot put a serum chop on ours, lah. You understand? We try and error, we learn quite a lot, and at the end of the day, sometimes we learn from judges. Judges are very nice to teach us what is right and wrong. Okay, so the other thing is from here, of course, most challenging. I like your question and yet humbling case. Okay lah, you know when I tell you about stay humble is yeah lah. Your lecturer also scold you, isn't it? The judges also scold us. You know, you don't go and fight back. You remember they're sitting up there. You know, you fight with them, they convict your client will scold you. Understand? So I agree with the question. You stay humble.
Yeah.
Okay?
Yeah.
So some of you who doesn't know the humbleness of you in your career is I always suggest watch Cinderella. Okay, believe me, you learn at the end of the day. The moral of the story is be humble. No matter how somebody go and scold you and all those things, right? You know. So when you stay humble, judges, I can tell you one thing, like you know, they know that this is your first case, or they know that this may be one of your cases. They know that you are prepared. They know that you are not prepared. You understand? So if you are quite
Yeah.
prepared, I can tell you who is well prepared for the case. You know, you can be half lah. You understand? But don't
Definitely.
quote me lah. You understand? Don't quote me lah. But you know, when you have a trial, you don't go and take chewing gum. You don't. Sometimes people tipu behind the mask. Don't do that lah. You know, that kind of focus. Okay, stay humble. They scold you. And then the other thing is, you know, sometimes when you have done something wrong, just say it lah. Look, I'm sorry. Okay, but sometimes some lawyers also will push you to the limit. Just stay humble lah. Okay, watch Cinderella. Moral of the story is stay humble. Okay. Anything else?
Okay.
I also watch
All
Cinderella.
right.
Okay.
Is it your favorite princess? I may ask.
I think I prefer if there's a Cinderella in Hindi lah, Kajol playing lah. Sorry.
It's okay. All right. Then that will be the first session for today. So thank you, Mr. Ram Singh, for the really insightful and stimulating discussion on the practice of criminal law, its realities, and its challenges. It is definitely a noble cause to defend those who may not have anyone else to confide in to clear their name. Thank you for the work that you have continued to do today for these people. Now is the time for our Q&A session with the audience, and I will pass this to Munira.
All right, thank you, Nadia. Hello, everyone. I'm back, and I will be conducting the Q&A session for this afternoon. You can now type in your questions to Mr. Ram Singh in the chat box, and I will ask them on your behalf. So now we have the first question with us today from Tina Ang. How do you deal with prosecutor when she or he may have refused to reduce the sentence of the defendant? Also, some judges may have hard to be cooperate with lawyers in deciding the sentence of defendant. What do you think, Mr. Ram Singh?
Okay, first thing, how do you deal with prosecutor?
Yes.
Okay, my answer is okay. Some prosecutors are okay lah, you know, okay. But the thing is this. In Sabah, we do have prosecutors who are police officers. Okay, that is for the police case, and we do have prosecutors like customs and corruption cases, right? Okay. who have refused to reduce the sentence. Okay lah, correction here lah. Defendants bukan. This is not America. Accused lah. Sentence of the accused. Okay. You just present your case. You give some part cases. There are cases to say if you think your client is best to go on bond of good behavior, BOGB, bond of good behavior. Or if you think that your client should be released on a fine, okay, and of course the prosecution will always push for higher sentence, right? Prosecutor, the prosecutor and the defense, it's just like this, the prosecutor will raise up the sentence, you will reduce the sentence, you will ask to reduce, right? And some judges may have hard to cooperate with lawyers. Well, judges have to cooperate with lawyers in deciding sentence of the accused, not defendant, accused. You just present your case. You present your case. If your client is sentenced to imprisonment, okay, imprisonment. That if you're asking for maybe normally you ask for less minimum sentence. Every punishment section have a minimum sentence. Okay, and then it has up to the maximum. Okay, normally the best would be the lawyer will put up what do you call it, a short written submission explaining how best that you want your client to be. Okay, so if you present your case to the best that if it somehow the judge sentence it to higher imprisonment. Okay, don't be disalarmed. Okay, you appeal. Okay, there's a right of appeal. Okay, under the CPC, Criminal Procedure Code, there's a right of appeal. So when you want to appeal, don't forget that you must ask for stay of execution. You understand? If you don't apply for stay of execution and then you go home, suddenly the family will call you and say, hey, he's sent to prison. So you ask for a stay of execution on the sentence and fine. But most judges want the fine to be paid. Okay, so you apply for a stay of sentence. Okay, and then you appeal. The thing is this: before you mitigate, speak to the prosecution. Talk to the DPP. I'm going to ask for 1 year. How much are you asking? Talk to them. Meet in between. They call it, and then before the sentence, there is another procedure which you can apply for plea bargaining. There's a Borang 29A, I think, plea bargaining process. Plea bargaining is allowed in the CPC. 28. Nanti we will email to you after this plea bargaining. Okay, 28A. You plea bargain, you minta hold on and then plea bargain. But if you think that you may have a good case, you just fight the case But if they reduce the charge, take the opportunity to plead guilty But once your client plead guilty, it's difficult for you to change your plea at the appeal stage. So difficult or not difficult, there is always an appeal process. The law is there. Don't go and scold them just smile at them and But you see, the prosecution duty is, of course, they want to, what do you call this? They want to uphold justice They believe they want to uphold justice But for us as a defense, what is our most and foremost duty is we seek the truth. You understand? So can't blame them if they want to be difficult with you You understand? That's okay. Next question. Is that answer your question? Oh.
Yeah, I believe it answers the question. So next question, greeting Mr. Ram Singh. Do you think there is a gender advantage when it comes to being a criminal lawyer, considering the nature of the cases? Thanks, sir. What do you think about this, Mr. Ram Singh?
Okay. Miss Michelle. What do you think? There's a gender advantage. I thought in my criminal practice, the judges, the prosecution likes lady lawyers, not guys. Maybe jokes aside Okay. I don't think so If you think that only male becomes a criminal lawyer, but but in KK lah, in Kota Kinabalu Court, the most magistrates are ladies, I think. We have ladies ladies magistrate, sessions court. Most of them are ladies. I don't see that lah, you know. But if you want to do criminal case, why not, you know? Present your case lah, you know, and do some magic lah, you know. Even no such thing lah. Don't worry about it lah. If you want to carry on with it, I have my 2 assistants who are ladies, Kimberly and Jay. And I do have some guys helping me also, you know. So I should ask them this question. Later I ask my lawyer also whether they think ladies or guys are better. But if you say that no gender lah, there should not be any. Don't worry about it. If you like it, go ahead with it lah, you know. And then most prosecutors also, they have ladies, very good ladies DPP and guy DPP prosecutor. And then if you look at federal court, we have more ladies than judges now, you know, at the federal court. So no harm. And try it lah, then you can answer me next time. Sorry lah. Okay. Next question.
All right. Thank you, Mr. Ram Singh. I think the answer would be, as of your view, there should be no gender issue. Okay, moving on to the next question. Hi, sir. When a judge says that a lawyer is incompetent, any threshold? That is the question.
You keep a moment and close your eyes and take a tissue and wipe your tears lah. And then you put on record, I wish to put on record that I'm very sad lah with that remark. You tell them lah, tell the judges. But no lah, a lawyer is incompetent, any threshold lah. Yeah, that's the last thing in your vocabulary lah. I think all lawyers are okay lah. Understand lah. Just because I lose a case, I cannot be incompetent, isn't it? Don't worry. When a judge says that a lawyer is incompetent, any threshold, I tell the judge and say, look, I object to that statement. Just say like that. I object to that statement. Or are you referring to me? But just smile. The best thing is, like one of the questions, stay humble. And stay humble. Go back home. Watch Cinderella. And you find your answer. Don't worry about judges. Judges will make every remark. But to me, I never came across this lah. They do scold me lah sometimes. Okay, that's all lah. But biasa lah, just like our parents call us lah. Okay, next question.
All right, moving on. Is it necessary for a criminal lawyer to do pro bono work? Is there any benefits can be obtained from it, perhaps in terms of career?
Okay, Mr. Brian, pro bono means free of charge. Of course, pro bono strictly means some cost to be paid lah, filing costs and this and that lah. Do pro bono, is there any benefit that can obtain from it? Of course lah, pro bono means, of course, benefits both ways. Accused may be happy and you may benefit from it lah, you know. But put on record before the magistrate or the judge that you know you are doing this on pro bono, and strictly pro bono lah. Don't go to the coffee shop and get some money lah. You understand lah? Pro bono means pro bono lah. Don't go and meet the fellow in the coffee shop and say, hey, you know, just now I argue, I sweat like hell, I argue until I don't have any more voice, and you pay me 5,000. Don't do that lah. That's cheating. Okay. In terms of career, yes. Of course, when you do pro bono, the court likes you. The court knows that you really mean it. You know, the judges, the public, you know, they have eyes and ears. Of course. And then as you progress in career, you know, do assigned cases lah. Assigned cases are for those capital punishment. Capital punishment cases, assigned cases. In Sabah, I think a minimum of 5 years, I think. Okay, minimum of 5 years, you do assigned cases, you know, and for capital punishment, not bad lah now. They pay about 6,000 to 8,000, I think. Okay, Those days, 30 years ago, I was paid 300 ringgit, I think, or 150. So do it. I know some judges who are elevated now, even up to Court of Appeal and Federal Court. They, in their career, they do a lot of assigned cases. Okay, that is your contribution to society, lah. Why not? I encourage you all to help. To help a lot. Okay, good. What do you call is good for your soul, lah. Okay. Next question.
All right. Okay, from Tina Ang, do you agree we as a lawyer should have put aside our emotional and religious feeling when assisting our client?
Yeah lah, I mean, put aside emotional and religious feeling. Yeah lah, when you fight a case as lawyers, whether civil, criminal, family law, what else? Simple contract, you may be suing your neighbor, you understand? So emotional feelings, forget it lah, Like I said, who are without problems, you understand? And then religious feeling, yeah, we are protected lah, under the federal constitution. Okay, religious issues should not be an issue in your career lah. You understand? If you want to help, you help lah. You understand? We have helped a lot of foreigners. I've helped a lot of Indonesians. I've helped a lot of foreigners who are charged for drugs, Indian nationals, Nigerians, Kenyans, and I just do it. But the only thing is that we don't put a Facebook lah. Otherwise, the Sabah Law Society is going to go after you also lah. Understand? So religious feelings, don't avoid all these things lah. Okay, you want to be better, let people respect you through certain things lah. Not this way lah. You want to have even judges also don't do that. Judges, so even my seniors also didn't do that for the last 30 years lah. Okay, so sometimes we seniors will tell the juniors don't go into that. So when the young counsels get a nod from a senior lawyer, take it as a lesson lah. Okay, yeah, we must put aside. Okay, we must put aside. Okay.
So the conclusion is putting aside. All right, another question from Atta. Mr. Ram Singh, in your years of practice, how aware are people of their rights from being arrested, investigated to trial? How often do police abuse this? This is a very interesting question.
In your years of practice, how aware are people of their rights from their being arrested? They know nuts lah, sometimes, people get arrested. Sometimes, how are people rights? People, okay lah, they are not lawyers like us, the police stop you and say, hey, look, what is the offense I have committed lah. People, they don't, but criminal, okay, like from being arrested, investigated to trial, okay. When they are arrested, they are suspects, They are suspects. They are not accused. They are just been arrested for suspicions, lah. You understand? Okay. The federal constitutions and also the police have their own lockup rules and checks, lah. They call it checks, where they are given the calls. The police will ask them, call the family. You understand? So the family get informed, and then they will get their own lawyers to go. Okay, and if not, then we have the YBGK. The courts, the YBGK from Sabah Law will assign their own lawyers to be in the lockup lah. Okay. Investigated to trial, of course, the first thing you do when your client get arrested, you ask, it is within the CPC, this 117, nanti we also email to you lah, since you bring up the word on arrest, 117, investigations, and detention for 24 hours. After 24 hours, you get detained for maybe normally 4 days to 2 weeks, depending on the crime. Okay, if you say that police abuse, not really lah, not now lah, maybe those days lah, if you look at cases lah, you understand lah. If you say that abuse, now not really lah. Sometimes if you go to I used to give lectures to young lawyers those days lah. I mean, if a client says, look, my son or my daughter has been arrested, you don't go to the balai in your jacket, blazer and say, look, I'm a lawyer, you understand? So normally be nice to them, talk to them, because they know that they have a right to counsel. It is actually provided in the federal constitution. So how often police do abuse? How often? Those days, maybe or maybe not lah. But but there is a process in court also. If they give statement, and then we call it involuntary statement, then there will be a process in court, right? Sometimes the magistrate doing the remand will ask, hey, you okay or not? Any health problem? Any this thing? Of course, the magistrate will not say lah, you kena pukul ke tidak lah. That word itself should not be there lah. You understand? But most people, they do not know their rights. So as a student, so it go by word of mouth. You start talking lah. Understand? That's the thing. But they have a right to counsel lah. The police will tell them, go and call your family members lah. Okay, I hope that answers you.
Okay. I have another question from Mr. Dyson Cole. Greetings, Mr. Ram Singh. What do you think about the recent amendment of criminal charges under Section 15, Clause 1, Subsection 2, ADB 1952, particularly dealing with the procedures of taking the urine test, which requires the usage of 2 bottles, 1 bottle? Is this able to provide sufficient justice to the OKT?
Okay, recent amendment. Amendment to Section 15, recent one, I am not sure, but the procedure of taking 2 bottles instead of 1 bottle. I've argued this case also. Of course, you must understand, you can have 2, if you have an offense of twice, Section 15, the third one, if you are positive, then it goes to 39(1)(c). You know 39(1)(c). 39(1)(c) of the DDA or ABD, Akta Dada Berbahaya 1952 is 5 years and 1 stroke. So no more. Section 15 is actually a fine. Okay, a fine maybe from 2,000 to 3,005 lah. Just a fine. Once, twice, the third time will be 39(c). 39(c) is quite serious lah. Serious in the sense that what do you call this? 5 years and 1 stroke. Okay. The 2 bottles test. The 2 bottles. There is a court of appeal judgment to say 2 bottles is required because of the IGP order, Inspector General of Police order. Then another judgment say 1 bottle is enough. Okay, depending on who is taking it, whether the doctor or the police. Okay. Is this able to provide sufficient justice or KT? The other thing also, sometimes there is a procedure on taking a urine. The guy will be there behind you. He will urine into the bottle, a tiny bottle. He will urine into that, and then there will be a marking lah. Understand? Of course lah. You can't expect the police to see how you urine, isn't it? That's the invasion of privacy. Okay. So these 2, there are cases on it. Justice to the OKT, my answer is very simple, Mr. Dyson Ko. Don't take drugs lah. Drugs is, just avoid. What to do if people take drugs? And then the other thing also, when you have 2, this is Section 15, and then we have the AADK. The AADK, the agency, Akta Agency Drugs Kebangsaan. They also have a right to take urine test and deem that you are an addict. Then you have to go to pemulihan. So there are 2 cases on that. Later on we email to you. on this lah, and then you can send it to Dyson Call lah. Urine test 1 or 2 bottles. The court says no difference lah. Unless the you know, when you do cases, you can see the seal has been tampered. Then the judge will look at it as that is and then correction. My name is, I don't sing song with a H. Okay, that answers you.
Alright. Thank you, Mr. Ram Singh. Okay, we have another question. As you mentioned earlier that you interview the witness. Does they always cooperate? If they don't, what are your alternatives?
Give them a tight slap lah if they don't cooperate. Sorry. Interview. You tell them whether they want to go to jail or don't go to jail lah. You know, and normally they will cooperate lah. But some witnesses will not tell you the truth. But when they start listening to the other witnesses, then they start talking to you lah. If they don't agree, what are your alternatives? You tell them lah. You know, you can find other better lawyers if you want lah. Understand? But most once they go on the stand and trial, witnesses will cooperate lah. Understand lah? You know, sometimes if you listen too much to the witnesses, you know, it causes you a lot of headache lah. You know, so you have to control your witnesses lah. The judges always say control your witnesses. You understand lah? Control your witnesses, you know, and then you don't tell them to talk all the stories lah, you know, don't tell them to talk about the grandfather stories. Like what I said, remember the charge that they have been preferred against. Stick to the charge. The charge is actually like you know, you take it like a kitab or it's a biblical word lah, you know, stick to the charge. Okay, if they say that they were not in KK during the crime, they were alibi, they were somewhere in Ranau, then use alibi. Understand? Get witnesses. So my answer is that you control your witness. You know, you understand. You know, if they don't want to cooperate with you, tell them like, look, don't blame you for going to jail. But don't say that lah. You're a lawyer. You're supposed to assist. Just control your witness. I'm sorry. Don't give them a tight slap lah.
Okay. Thank you, Sasha, for the questions. Do you have any more questions?
Any more?
Let's see. Yep, we do have another question from Mr. Ruben Lin. How is it like to go against the DPP of Sabah? Are they generally difficult opponents to have?
Okay, how is it to go against the DPP of Sabah, and are they generally difficult opponents to have? Actually, to be honest with you, most of the young DPP of Sabah is from Sabah, you know. Not bad lah, Sabahan, you know. The seniors are, of course, from Semenanjung, but whether the DPPs, I have no problem with them lah, you know. But that is why I said before a trial or before your case starts, talk to them. You know, don't just sit in one corner, play with your handphone, go and watch YouTube, you know, go and sing song like that, and then when the case starts, then talk to them. Don't do that lah. Okay, you talk to them. You talk to the DPP, you talk to the police. How is it like to go against the DPP? This is, you're asking me how to go against them. Can also lah, sometimes they also lawyers like you, you know, sometimes they also be nice to you. They also want to be nice to you. Okay, how to go against DPP in Sabah. In most cases, we don't go against them, but a lot of incidences that lawyers against lawyers, okay? I can tell you lah, DPP, Ida lah, they're okay juga lah. And are they generally difficult opponents to have? No lah, they are nice people lah, DPP. Okay? Sometimes your client can be not nice to you. Are they generally difficult opponents to have? To me, they are nice lah. Maybe to the DPP, they say I'm difficult lah. Okay, so don't worry. But anyway, I will ask the DPP about this question also lah. I'll ask them also lah. Good question lah. And then I hope Mr. Lim here will be a criminal lawyer lah. Okay, next.
All right, we have the last question. Let's see what is the last question from Mr. Aaron Ma. Mr. Ram Singh, has COVID brought many changes to the way you practice?
Okay, Mr. Aaron. COVID has given me two things, you know. One, being positive myself and positive in my future cases. You understand? So I always think positive lah. Okay, not negative. Okay, but COVID on the practical side, okay, it really taught us to work from home lah. That is been lazy lah, Aaron. Okay, and COVID has many changes to the way of practice. True, I agree. Sometimes appeal cases, you know, it's not face to face. So the last hearing of the appeal cases here, I actually told the panel, I say, when can we have a face to face physical? So we were assured of most probably in May. Okay, but otherwise cases still move. Cases still move through Zoom online, macam ini lah. You understand? So, but honestly, COVID, I was positive in COVID, and my practice also very positive. So we don't say negative now. Okay, Mr. Aaron. Anyway, Aaron is a nice guy lah. I don't want to say much. Okay.
All right. Thank you, Mr. Ram Singh. And that was the last questions of the day. Thank you, everyone, for your questions. So, once and once said that experience is the best teacher that one can have. I believe that every input that Mr. Ram Singh shared with us today is something that can only be achieved through years of practice in the industry, and we cannot thank him enough. We really appreciate you, Mr. Ram Singh, for the tremendous input that really gives us a glimpse of criminal law practice. And thank you, everyone, for your wonderful session and questions.
Yeah.
Since we are running out of time, I'll end the Q&A session here. Over to you, Nadia.
Thank you, Munira. I would like. Okay. Thank you, Mr. Ram Singh. All right. I would like to thank everyone for taking the time out of your day to join us in this much anticipated and exciting session of this webinar series. We hope that the wisdom imparted by Mr. Ram Singh has been an eye-opening for those in attendance, as it definitely has for me. In the meantime, take care and stay safe, everyone.
Okay. Thank you.